good morning if you're in the US, and good afternoon and good evening wherever else you are. So this is USALI Speaker Series. I hope you have joined us in the past. I'm Jose Alvarez, the Faculty Director of USALI. Let me introduce an old friend of mine. I used to be at Columbia for a number of years, and it was instrumental, I hope, in getting Columbia to see the wisdom of hiring Petros Mavroidis, who was at that time affiliated with the University of Neuchâtel, but having just come for many years in the legal division of the WTO, where he served from 1992 to 1995, and has continued to be a legal advisor to the WTO. Therefore, you can count him to be not just an academic, but a WTO insider. And I think Petros prides himself on being a practical academic as opposed to a pie-in-the-sky academic. Officially, he's the Edward B. Parker Professor of Foreign and Comparative Law at Columbia Law School, and he's been the chief co-rapporteur for the American Law Institute study, Principles of International Trade, the WTO. The first two volumes of his book, The Regulation of International Trade, won the 2017 Certificate of Merit in International Law from the American Society of International Law, and Volume 3 was published in 2020. He has been a faculty member at Columbia since full-time since 2003, and his education, as well as the many languages he speaks, is global. So he has a doctorate from Heidelberg, an LLM from Berkeley, another master's degree from Brussels, and his original law degree is from the University of Thessaloniki. And therefore, he brings, I think, a cosmopolitan perspective, as well as the fact that he has taught at a number of law schools as a visitor, including the European University Institute, the EUI, in Florence, Italy, as well as Woodrow Wilson School at Princeton. With all of that, take it away, Petros. I understand you have a PowerPoint to share with us.
This is a book with a mentor and a good friend of mine, André Sapir. It's called China and the WTO, Why Multilateralism Still Matters. The book came out this month by Princeton University Press. And Jose asked me to give a brief presentation of the book so we can have a nice discussion about the argument of the book. And what is the argument of the book? Well, the argument of the book is China joins the WTO in terms that now we think were inadequate to deal with the China problem as we now understand it. And in a nutshell, the China problem is what? Well, it's state control over national economy has not been tamed. Now, we have hindsight 2020 here. We're Monday morning quarterbacks, so we try to reconstruct what happened from the day China joined and until nowadays. And what we did in this book is we tried to argue that the views and the tactics so far how to deal with China, in our view, are suboptimal. There are essentially two views, if you wish, two diametrically opposed views. One, head-to-head confrontation. This is the Trump administration attitude for a few years now. The other is stay idle because the WTO can and should accommodate China's regime. So what we try to do is that in this book is we try to say, look, China is an issue and it must be addressed. But neither unilateralism nor staying idle will help. What we need is some clarification of the existing rules and some new rules if we want to address the complaints that trading nations have advanced. So this is again the argument. Now you can see the argument more clearly. And now my outline. So I'll go through the book, through the argument of the book by asking four questions sequentially. First, why is China an issue? Second, why was it not addressed, the issue, at its accession? In other words, are we facing a surprise effect, something that happened post-accession of China to the WTO? Or are we dealing with something we knew about and we simply did not take adequate precautions? Then I'll move to explain why the options advanced have not worked or could not work. And finally, our proposal with André, what can and should be done now. Now, why is China? Let me start with this. Why is China an issue? I would say in one sentence, China is an issue because of its success. So look at China 2001 and look at China nowadays. I'm not saying that this success is due to the WTO, but the WTO has contributed. China now, if you recall, in the 90s, had to request every year permanent normal trade relations with the US every year. Now it's a member of the WTO, has unfettered access to 163 markets around the world. In terms of exports of goods, from 6th place, when it accedes to the WTO, it's now number 1. GDP at constant prices, same timeline, multiplied by 5. GDP per capita at purchasing power parity, PPP, from the level of Sudan, more or less close to Mexico nowadays. But this export-led growth model has been the centerpiece of criticism. The tinderbox was the trade deficits with the US, but others, and more vocally EU and Japan, have joined the chorus of criticism. Now, one might say, why should we be upset with China? Isn't the WTO about expanding trade? This is not a zero-sum game. We can all profit from this success. Well, yes, but the view is if we all play by the rule. And the critique against China is that China does not play by the rules. Sometimes it does not observe rules, the letter of the law, and sometimes it does not adhere to the spirit of the law, the GATT WTO liberal understanding, to which I'll come back in a moment. Now, I have to say one thing before I discuss, as a prelude to the GATT WTO liberal understanding. The GATT WTO is an obligationally incomplete contract. It cannot be otherwise. Anything can affect trade, and discipline should not be imposed on outcomes. They have to be imposed on conduct. So every conduct essentially has to be somehow disciplined. And as you can imagine, disciplines for this very simple reason cannot be detailed to perfection. And this is one source of acrimony and one source of the China problem. But most importantly, what's the liberal understanding? Well, when we go back to the original GATT, 1946, when the negotiation starts, there was a lot of negotiation between the original players who should be invited to negotiate the GATT. And following a Canadian and to some extent US proposal, US is essentially the mastermind behind the GATT WTO, the original GATT at least. The idea was that it would make much better sense to invite a nucleus group, like-minded players, a different level of development, not all of them fully developed nations, but like-minded players, Western economies, to negotiate the GATT and then take it from there. This is for a number of reasons which have been explained adequately in literature, and most recently in a comprehensive study by Ben Stile of Council of Foreign Relations, which I particularly appreciate myself, where the link between the GATT and the Cold War is made black on white. Now, China is an apple of discord against this background. It is not what you would call a Western economy by any stretch of the imagination. Now, the counter-argument here is what? Well, the GATT was the GATT, but don't tell me that the WTO membership is homogeneous, like the GATT was. No, it's not anymore. But in the past, the GATT managed to accommodate diversity. It faced either the accession of small socialist countries, Hungary, or big countries with state involvement, like Japan, but never both, never big non-market economies. Japan, by the way, almost immediately thereafter joined the OECD and became a full-fledged Western economy. Now, if the combination size and economic regime proved overwhelming for the WTO, and they were unique in China's case. So all of this, of course, we knew it. We knew that China is not a Western economy, and we knew the size, and we knew the forecasts before China joined in 2001. So the natural question to ask, and this is one of the questions we ask in the book, on the way to build our argument, is, well, why these issues were not addressed a little bit more in more detailed manner during the accession process? Now, here we have to take one step back and rethink a little bit the working hypothesis when China is about to join the WTO. This happens in 2001, end of the negotiations. Negotiations ran parallel with the Uruguay round, 86 to 95. And the idea was that China would transform into a market economy. We cite in the book numerous accounts by various US presidents, from Clinton to George W. Bush, US congressmen, the EU hierarchy, the WTO DGs. Everybody's convinced China will become a market economy, aided also by the accession to the WTO. They saw a lot in the reforms of Deng, and they think WTO was, if you wish, the apex of the road, the one-way road towards market economy. But not only that, especially in the US, a number of political leaders, we have a couple of declarations by Maudlin Albright in the book, cited one after the other, next to the other. China will become a democracy as well. I mean, the idea was, well, all human rights-based regimes are market economies. Transformation to a market economy automatically leads you to a regime change. And this view influenced, if you wish, the terms and conditions of accession. The leading negotiating partners, EU, US, they bought into this idea. Now, what are the terms of engagement? Well, when China joined, like any WTO, any new WTO member, there are three layers of obligations. There are the multilateral obligations, which bind all membership. China has no discretion. They must observe those rules. There is a plurilateral layer. This concerns, I mean, the only meaningful agreement is government procurement. Participation is optional, and we don't care about it because China did not join the government procurement agreement. And the third layer is idiosyncratic, concerns the acceding member only, the Protocol of Accession of China. Now, the Protocol of Accession of China naturally looks into or focuses on the state involvement in the Chinese economy. There is a paradox, if you wish, when the negotiation takes place, because, as I said before, the Uruguay round and the Chinese accession progress hand in hand, almost simultaneously. And yet, in the subsidies agreement, no one thought of mentioning the term state-owned enterprises, although some existed in few WTO members, but they knew China is coming. And China was full of state-owned enterprises. So the term state-owned enterprises, which is missing from the SCM, was negotiated into the Protocol of Accession, but the disciplines, as I'll show you in a moment, are quite shy. The other focus was on transfer of technology. Now, let me say just one thing here and more later. The idea in the Protocol of Accession was, what kind of disciplines should we impose on China, on the state, not on private actors? Now, why did it happen this way? You see, there is a legal explanation. And the legal explanation is this. A protocol of accession is protocol of accession to the WTO. You cannot impose conditions on areas like investment, which is not regulated by the GATT. There is a little bit of investment in Mode 3 in the GATTs, but just for some services. You cannot impose disciplines which the rest of the membership does not abide. You enter into the WTO. You don't enter into a human rights convention or an multilateral investment agreement. So the protocol of accession could not address a number of issues which became real concerns later. Adjudication, by definition, has to take place within the four corners of committed law. The WTO panels and the appellate body, they're not courts of general jurisdiction. They have to apply the law that the agents, the membership, has committed to, which means they cannot rule on issues which might be legitimate, but which lie outside the four corners of WTO regimes. And over the years, we realized there's an additional problem. The incentives to adjudicate are often missing. There is notorious under-enforcement concerning China. There are a number of empirical studies by economists showing that if you use, for example, I give one here by, this is actually two different papers, one by Davis and Wei, one by Baum. If you use trade share as a proxy, the volume of cases against China is much lower than what it is against the US or the European Union, and so on and so forth. So, the protocol of accession, I have a thing here, I sum it up. What is the end game? China does make serious tariff concessions, but does not make promises to transform its economic system. Now, it does not make for two reasons. One, you cannot go very far through the protocol of accession because, for example, there is nothing concerning investment in the WTO. And the other was the belief that China would anyway change because it was on a one-way street towards market liberalization. Now we know not only that China did not change, but President Xi even pushed the other way back as of 2011. So the question is, what should we do now? Well, we didn't have to wait for long because the first response toward China, I leave aside the litigation before the WTO, to which I'll come back in a moment, was the US, no, I shouldn't say US because I don't want to equate the Trump administration with the US. The Trump administration attitude towards China, which was essentially take China head on, impose unilateral duties, negotiate a little bit phase one, phase two, but also hit them hard unilaterally. We know it hasn't paid off now. China doesn't mind paying back, doing the same thing to the US or facing duties. And a number of studies, one colleague of mine in the economics department at Columbia, David Weinstein, has a fantastic paper with Amriti, three or four co-authors, which we cite in the book, shows actually that a lot of this cost is borne by the US, which is normal because when you impose countermeasures, you have to take a huge, let's say, hit in your own economy. This doesn't work. Should we do more intensive adjudication? Remember what I said, incentives are missing. There are lots of accounts supporting this view. A number of people like Jennifer Hillman said, well, we can go ahead and introduce some additional non-violation complaints. We disagree because non-violation complaints, we can discuss it later what it means, but essentially it does not oblige the respondent to change its policies. The respondent, all it has to do, if it loses, first of all, the if is big because it's a huge if, because the evidentiary requirements are quite high. But let's assume China loses. All it has to do is pay some money. They have a lot of slack to pay. Staying idle, the Danny Rodriguez view, well, this does not look very persuasive either to us. First of all, because problems persist. And second, as I showed you before, the whole idea of the GATT was to have an implicit liberal understanding. It was not the idea that anyone, any communist regime can be part of the GATT WTO, not at all. So against this background, what do we say? Now, when we look, we take first of all here the complaints at face value. We don't say why you complain about this and not about other issues. And we look at the complaints before the WTO. We're not suggesting anywhere in the book that there are no other complaints. For example, transfer of technology is not just a trade complaint, it's also an investment complaint. But you cannot do much about it in the WTO as the WTO now is. We don't discuss at all things like human rights and so on because they lie outside the WTO. So we look into state-owned enterprises and transfer of technology, which, if you wish, monopolize the wish list of the trading community. Now, we see a difference as to what should be done. State-owned enterprises, in our view, is largely self-inflicted damage, in the sense that the law, if it had been interpreted in a contextual manner and in a consistent manner, maybe we would not be where we are today. To us, the appellate body, this is one area where the appellate body has been, I have to say, speaking for myself more than for my dear co-author, Professor Sapir, I'm very skeptical of the quality of the output of the appellate body in general. But here it's one of those areas where I think many people would agree with me that they've done serious mistakes. State trading enterprises, they confuse price discrimination with discrimination as per Article 1. And essentially, they threw the baby and the bathwater out of the window. They made the non-discipline out of Article 17. And when it comes to public bodies, they moved, it's like Foucault's pendulum from one side to the other. Earlier case law says state ownership does not even create a presumption of non-market behavior. Subsequent case law, a year and a half ago, suggests that even private agents could be public bodies if you can show links without looking into the conduct of the company. Here, quite frankly, one might say, well, we can change this by changing the judges. True, but clarifying the law, to us, is the better option, because this is a way to preempt abusive judicial discretion in the future. And in the book, we suggest ways. We don't have to reinvent the wheel. TPP and CPTPP contain disciplines which, in our view, are very adequate. And remember, TPP was negotiated by President Obama, keeping in mind China. They negotiated an agreement to tame Chinese SOEs without China being part of the agreement, part of the negotiation. So this is a very adequate framework, and we suggest copy TPP Chapter 17 in this respect. Transfer of technology, I repeat, transfer of technology now we discuss in the context of trade dispute, not in general. The problem cannot be addressed absent new agreements. A number of requests for consultations concern cases where a Chinese company has refused, a private agent has refused to enter into a joint venture with a foreign company in the areas where this is still the case, absent transfer of technology. Now, what can you do against a private agent? Nothing. As things stand, ideally, you would like to have a multilateral investment agreement. This, of course, we understand is a long-term endeavor. Lighter version would be change a little bit the provisions of TRIPS. Again, look at CPTPP, which makes a distinction between imposing and enforcing transfer of technology, thus taking away from states the possibility to enforce forced transfer of technology, and by backwards induction, reduce the incentive of Chinese companies to behave in this way. I want to finish in 20 minutes, I promise my dear friend Jose, less than 20 minutes. We did a book concerning, I've told you the main lines of our argument concerning China as a trading partner in the WTO. And of course, analytically, we made a convention with my dear André. We looked at trade in self-contained manner. We're not oblivious to the fact that there is much more at stake, that we might be facing it to see this. There's an excellent book by Graham Allison, 2017, to what extent now we're in the moment where we pass from Pax Americana to Pax Sinica, just like 70 years ago, went from Pax Britannica to Pax Americana. All of this, we take it on board and we accept the limits of our analysis. But we believe that if the multilateral regime can help address the China problem, it can also help avoid the wider crisis. Our proposals are in line with the spirit of the WTO, and I explained why neither unilateralism nor staying idle is an option. To us, this is the time to invest more in the multilateral regime. And with this, I thank you and I stop And Jose, I have respected my 20 minutes.
Thank you very much, Petros. If you want to stop the screen share, that way people can see you as you respond to questions. And we will be going to your Q&A questions. So start writing them and I will handle them and screen them. In the meantime, Petros and I will engage in a bit of conversation. I was lucky enough to see a good chunk of his book. I highly recommend it. And apparently, according to what the publisher tells us, it's being published simultaneously in Chinese, and there is an incredible advance order of 500,000 copies from inside China. So I'll start there, Petros. How do you see your recommendations being seen inside China? And I guess you could split it up into the Chinese government, in the Communist Party, as well as the private companies and even the SOEs. Are they likely to see the same thing across the board? Is there unity in how they approach this? And I ask this because there is a heavy, very heavy, as you know, political element here. That is, there's a serious question as to whether China wants to adapt itself to the embedded liberalism model that the WTO embodies, or whether China is now embarked on changing the WTO to its model and trying to convince through Belt and Road and other ways of influencing hearts and minds that its state-led is very successful. Look at the growth rates. And therefore, isn't the idea here that China has is, no, you change to our model and we'll all be more successful. Why should I change to yours? And part of it is, of course, political. I'm reminded as I read your book, I'm from Cuba, and Castro used to say, everything is possible within the party. Nothing is possible outside of it. And that strikes me as the president of China's own view. We control SOEs. We also control, if we need to, private companies. And therefore, there's really no distinction when it comes to high-level politics as to the Chinese control of the so-called marketplace. So I guess, to me, that's the question. How do you think this is perceived in China? And why isn't the answer, no, from China anyway, no, you change to our model, not the other way?
It's something which has been in my, that's why I respond right away. Don't think it's not an off-the-cuff response, although it looks like off-the-cuff. It's something which has been in our mind for a long time and was in our mind when we're writing the book, as you can imagine. The idea was, we didn't want to write the book, as you said, the pie in the sky, something which could work. Now, when we presented these ideas to a number of fora, and of course, a number of times we had to confront Chinese officials. The idea that, I'll give you two responses, very brief, don't worry, I don't like the sound of my own voice very much. The first is, I think Chinese, if they're willing to negotiate something, if they want to take one of the options on the table, that's the one where they can sit down and negotiate, because the counterfactual could be either bilateral deals or bilateral threats. And, or even worse, it could be the case that they might be facing a consortium, a transatlantic consortium. There is a trilateral committee, Japan, EU, US. God knows how far they will cartelize their response. So maybe this is them. China, as you said very correctly, they think they have something to offer in negotiations. So maybe this is the way they can say, okay, that's an olive branch. I can sit down with those guys and see what can be done. Since I have signed the SCM agreement, what can be done for me to accept a little bit of pushback of the state in order to have a peaceful WTO from which I profit a lot, as the numbers show. They don't want to leave the WTO. Now, the other thing which I deplore, in the past, it's amazing how you change your views in life. There's one thing I've never changed my views about, my wife, for the last 30 years. But for everything else, almost I think I've changed my views, honestly. So I was very critical of the negotiation in the WTO concerning common competition rules. I couldn't understand why should the WTO sit down and negotiate. And yet, Jose, and this is the amazing thing, now in hindsight, I say, I wish those guys had done something more in that context, in the context of common competition rules. In 2003, China is in the WTO for 2 years. They have 4 items to add, and they drop investment and competition. The 2 items in Cancun, where China is, if you wish, is criticized about. The WTO decided no multilateral action. Now, why is this important? State-owned enterprises exist in the US, few, more in Europe. But there, they have to operate within a competition regime. A state-owned enterprise in the US or in the European Union cannot say, I'm like baseball, I have an antitrust exemption, I can do whatever I wish. I have to observe the Sherman Act. I have to observe Article 101, 102 of the European Union TFEU, Treaty on the Functioning of the European Union. I cannot behave as if I am shielded away, insulated from competition. In China, they can do, the sky's the limit. So much. Not only this, on top of them, they have a superstructure, the SASAC, which cartelizes all of activities by state-owned enterprises. So if you wish, again, in a sense, it is a self-inflicted damage. We started the negotiation, which could have taken us somewhere. We stopped it for no apparent reason, and now we are where we are. So when I take everything on board, past negotiations, some experience, China wins from the WTO a lot. Is it willing to sacrifice all of this and saying no? Then they run risks like the decision of the DS437, this is the last appellate body decision, which says even private agents in China could be acknowledged as public bodies. They risk this type of decisions, and then they might be losing even more than if they sit down and they negotiate intelligent rules concerning the last point here, Jose. I'm not saying that 100% this is what will happen, but I'm saying this is by far the most realistic and the most balanced way to solve the problem.
Well, that's great. We are starting to get some of the questions in the chat box, but let's just pursue a few of the things that I think your PowerPoint demonstrated. One is, you mentioned the EU-China recent agreement. And of course, we have the agreements that Trump negotiated. And there, if you're talking about Europe and you're talking about the US, can you say a bit more about why a multilateral, or what you call a plurilateral solution, is absolutely necessary? If we have Europe and, say, the US, through bilateral arrangements, trying to deal with this, isn't that enough?
Maybe it's enough for Trump to sell it to the US constituency and for Europeans to Europe, but does it solve the world trade problem? This is my angle. My angle is not the US or the EU national, the EU national interest at all. You see, first of all, there are transaction costs. The agreements do not see eye to eye. Both agreements fail the MFN from the little I've seen. Phase 1, it's clearly managed trade. There are a number of papers. My friend Gary Hofbauer has 6 or 7 papers in the Petros Institute blog. It violates each and every understanding of MFN. But the European Investment Agreement is not exactly MFN either, although we haven't seen the specific commitments. There is a lot of language which is between Europe and China. It's very difficult to make an argument that everybody will profit from that. So you shift costs to other parties. Somebody else has to pay. If I give an advantage to you and not to Dr. Wilhelm, who I see in the picture, not herself, but her picture, well, then I shift costs to Dr. Wilhelm, and maybe I would have been better off if Dr. Wilhelm would have been part of the game. Maybe I did not pick the best, the absolutely most efficient producer on earth to transact with. That's the beauty of international trade and MFN. And if you want to take it a little bit further, because you and I will have a human rights background, you much, much more than me, of course, trade, at the end of the day, the conception of trade liberalization in the 40s was not just economics. I mean, Cordell Hull, who got the Nobel Prize for his work at the UN, his conception was this is day-to-day communication between peoples. This is a platform for world peace. All of those things are missing the moment you start moving into bilateral deals. Now, having said that, last point about your plurilateral thing, the reason why I'm in favor of plurilaterals at this stage, it's transaction costs of the in WTO negotiation. You know, if we get the big guys around the table, and I want to say the big, it's not just US EU, but US EU, China, India, Brazil, a couple of African states. If we can get those guys around the table and come up with a deal, 70, 80, 90% of the production, 20 players, then this can be very easily MFN. But we want to have the big guys, and it's much more realistic to have an agreement between those who matter than between those who don't and might be putting all sorts of requests at the negotiating table.
Okay. So when you say plurilateral, what you're meaning is, I guess, is it still an agreement that would still be subject to some form
Yes.
of dispute settlement, right?
Yes, under the WTO plurilateral. Sorry, I should have said that. Yeah.
Okay. So, so before I turn to some of the questions, and again, there's some really fascinating ones. One of the things that comes out from this is that it isn't clear to me that you would strongly disagree with the complaints, the many complaints that Trump had about China's policies as being inconsistent with WTO. I'm thinking of the 2018 USTR report, which is like, you know, a brief of horror stories of how China is not in compliance. So what the problem was the tactics. That is, you think the tactics were wrong, and had Trump been inclined to work with allies and work to try to reform the WTO, he was not wrong in shifting the tone, which is really quite hostile to the WTO. And I guess I want to press that with you. That is, this notion that we just didn't anticipate that China would be so inconsistent with the WTO, you branded as optimism on our end. But at the side of, from the China's perspective, you know, the more I've read about how they thought they were adapting to the WTO, they had to change thousands of laws. They were adapting to a whole scheme. And it was evident to everyone that they had state-owned enterprises, and nobody could have assumed that they were just going to give that up and turn into some variation of Europe, right? So
Yeah.
who really was at fault here in terms of this? Was it just bad plays on both sides?
You know, there are, again, two, but these are excellent points, Jose, excellent points. The first is, you see, the one thing where I blame negotiators is when you look at the Chinese economy from 1989, when you start the negotiations seriously with China, especially after 1994, when you know the subsidies agreement does not even mention the term state-owned enterprises. Why can't you add a footnote in the protocol of accession and say every state-owned enterprise presumptively is a public body, and then they're subject to the disciplines of the SCM agreement? I don't know what was the quid pro quo for that. I don't know if there was a quid pro quo, but to me, innocently, I would say it's an oversight. It is not, it doesn't make sense. Now, I accept that nobody could foresee, maybe it was very difficult to foresee that China would not only not change, but also push back some of the reform. But I think, again, in hindsight, the key event is 2008. When we went through the financial crisis, first the US and then Europe suffered a lot. China, much less. And this gave the regime a lot of confidence, saying our regime can fare so much better than the Western regimes people have been talking about all those years. And there is a lot of evidence in the literature and the Chinese press that this was a huge selling point in China and a reinvigorating point as far as the relevance of the Chinese Communist Party is concerned. They came out strong saying, look at us, Our regime is a shield against this type of crisis. Their regime is faltered. Do you really want China to go back, imitate those guys who lose, go take unemployment from 3 to 23% within 3 years?
And aren't we in the same position again? Can't China say, look, we've been backtracking, but it's proven fantastic. We're the only economy that's growing at this rate in the age of COVID. So isn't Chinese self-confidence on that level even more likely now?
Maybe. And the other point, which we have discussed, you and me, and I was thinking about it a lot actually yesterday, is this trade human rights link. I mean, this is the one area that I never understood, Jose, because even if you believe that China is on its way to becoming more liberal, in what do you have confidence to think the level of human rights protection will change? I mean, in my view, either the argument that I buy is that this was just a fig leaf. Nobody believed it, but because of the gains in terms of political economy, I satisfy 3 lobbies and I'm elected again, I'm prepared to close my eyes to those things. This is the argument that I buy. Or quite frankly, there is something fundamentally wrong with the way our politicians think.
Right. Well, on human rights, obviously there are lots of people who think that the Biden administration will try to do a lot of the reforms that you're suggesting, but that they will refuse to de-link entirely human rights from trade issues. And again, part of the problem, as you and I have talked about, is that if you're talking about the WTO, it has no expertise in human rights. These are trade people. So how do you embrace human rights in an organization that thinks human rights is not part of their mandate? And yet, right now we're talking about an administration that is about to brand China a genocidal murderer. And it's hard for me to imagine that you can call and treat a state a murderer Monday through Wednesday and do business with them Thursday through Sunday. So is there any way to deal with the human rights issue, even when you're talking about trade?
Yes. I mean, and now you will see why I said I've been thinking about it. I have a full-fledged response now to this, not a half-baked thing like the other day when we were discussing. You see, there is nothing like a democracy clause in the WTO. Dictatorships have entered the WTO and they have stayed in the WTO as members, all in the name of negative integration. It is for WTO members to have their mix of policies. Now, there is nothing at the WTO doesn't mean US, Cuba, Europe, India, my home country. We cannot stop trade on human rights grounds. First of all, the individual members have lots of power in this respect. At the moment of accession of a WTO member, if I think it is not a human rights protecting entity, I can say you can join in, but I invoke the clause of non-application. I am not applying at all the WTO towards you. You can do that. But even later, you can always invoke Article 20. You can say, your trade regime goes against my public order. I am not going to deal with people like you. You can do it unilaterally, but there is nothing like a WTO clause to stop accession of China. You cannot enter the European Union if you're not a democracy. And I think the most valid argument is you cannot be a member of the European Union unless if you continue to be a democracy. So if you change halfway through, they have to expel you. But in the WTO, you can join, you can stay, and you can leave being a dictatorship. So, but the Biden administration can definitely do it if they want to do it. And maybe they'll find imitators. The question is this the most appropriate means to persuade China to change? This is what I think the Biden administration should do some thinking. Is it through trade measures or is it through other measures that you should be doing? Or through a combination of measures? I'm not saying it's not a zero-sum game here. Maybe you can do different things.
Well, the other, so let's pursue a different line, because one of the more fascinating aspects of your book is the distinction between SOEs and TT in terms of whether the rules were adequate to begin with and how much should we rely on adjudication. And what your book provides for me is a sort of refreshing candor about the limits of WTO dispute settlement. And so you basically are indicating you don't trust the judges. And in any case, it's not entirely their fault, because they are just the agents of states under Article 3.2 of the DSU. They're not supposed to add or diminish the agreement. So they're limited. They're not lawmakers. So unless it's clear in the rules, they can't do much about it. And second, you mentioned, but you don't say more about it, maybe you can, the incentives to adjudicate and why people don't go after China. Is it just it's too big? They think that even if they win, they don't really win, because what good is it to win a trade remedy, tariffs against big China? Is that the reason why states don't sue China enough? And then finally, you talk about criticizing Hillman's approach to non-violation complaints. And maybe you want to say more about why that's not a solution, quite apart from the remedy not being adequate. So I guess one of the reasons I'm curious about this is, as you know, everybody's talking about reforming the WTO dispute settlement as part of a bigger question. And I guess you're casting some doubt as to how much you can really reform it, or how much what I get from your book is fix the rules first. And if the rules are good, then maybe you can trust the judges to do their job. But if the rules are ambiguous, they're likely to screw it up. That's a very different take on global courts than I usually hear from Europeans, who they seem to love every kind of court that they can find, whether it's anti-terrorism court, anti-human trafficking court, you name it, investment court, we want it. And I think you're dumping cold water on it. In fact, one of your articles suggested this incredible proposition that judges should issue non-liquets that just admit that there are no rules here. What kind of a European are you?
I'm not very European, I think. I'm of Greek origin, Swiss. Spent half of my time with you in Ann Arbor, then New York, Berkeley. What do you expect? I'm married to an Indian for 30 years. I mean, now I'll take all of these are great points. Let me go through them with 2 sentences for each. Sorry for this. I mean, this deserves much more than 2 sentences, Jose, but we can continue the discussion. I assume there are other people who want to speak as well. First of all, one of the many, many things I owe my co-author, André Sapir, as the list is extremely long, is when I was getting exuberant about problems in WTO, he used to always caution me and tell me, don't forget, this is the process. This is the only compulsory third-party adjudication regime we have. And this I'm a big fan of. I don't want to see disputes adjudicated through gunboat diplomacy. I want to go to a judge. So this is, if you wish, the big picture. Now we discuss the details. How do we make this court more efficient? Now, I'm going now through all your points. The incentives point. We cite in the book, I didn't speak much about it, but we cite in the book a lot of evidence, which we found in other accounts. There are a number of, from economists who worked, to businessmen, we cite, to investigative journalists. For example, to give you one example, high-speed train investment in China. You have a consortium of a Japanese, a German, and I don't know if it was a French company. They all 3 are requested for transfer of technology. Japanese refuse to provide transfer. The other 2 bite the bullet. Next contract, the Japanese are out. Now, what is the story for the German investor? If you bite the bullet, if you don't over adjudicate, you have a huge chunk of the Chinese pie, which is huge. They continue to play the same game. On judges now. Sorry, before I go to Hillman first and then to judges. On Hillman, because judges is the most important of all the questions, I think. The first big problem when you do a non-violation complaint, I mean, let's forget now the remedy issue. This is the side remark, is the evidentiary requirements. So when I'm in a non-violation complaint, we agree, you and me ex ante, and the judge has it in the back of her or his mind, that there's nothing wrong, legally wrong with the practice. The practice is legal, but it defies expectations. Now, what is the associated burden of proof? The burden of, not only production, but also persuasion, the standard of review that the judge will apply. I have to show that a practice took place. If it has taken place before we exchange concessions, as is the case for the majority of practices in China, I have to show that, well, although I knew about it, I was surprised by the magnitude of effects. I know no one who won a case like this. Ideally, you win a case if the challenged measure is subsequent. After we exchange tariff concessions, you do something which puts into question the value of concessions. And then I have to prove what I expected to win, how much I won, which must be less, and attribute this loss to the legal practice. This is a very tall order. It is not, because I like practice very much, it's not paradoxical that the last winning non-violation complaints are 13, 40 years old. It's not paradoxical. It's because the evidentiary proof is extremely high. That's why people they always go. Of course, the fact that the count has been completed makes less and less the need to decreases the value of non-violation complaints. But the evidentiary standards are very important, and that's why people don't win those cases. On the judges, you're absolutely right. I prefer to have to give little discretion. Now, sorry, Jose, let me say one thing before, so there's no misunderstanding, at least between you and me. I'm not speaking about if people like you were judged. It's a different discussion. I'm speaking based on my observations. The judges I have seen at the WTO over the years. Now, when I look at those judges, who none of them has training like yours, none of them, the judges at the WTO are not law professors. They are former, wait. I mean, everything matters. These are ambassadors. They come with a different skill set. They are ambassadors who negotiated for their country for years, the overwhelming majority, or they're trade delegates, not even ambassadors. Most of the panelists are first appointment in Geneva. Inexperienced people. These are the WTO judges. When I look at those guys, I ask the question, who, quite frankly, and I think I've spent a lot of time on this, with different co-authors, with my very dear friend Henrik Horn, we started doing this thing for a very old co-author of mine, many, many years. We looked into identity, education, skill set of judges, everything, whatever we can find on the internet, of course. It is disappointing. I'm sorry. It is disappointing. Now, if I tell you, Jose, subsidies are illegal, Cuba is paying producers of sugarcane X, is it a subsidy? You'll give me a response in 2 seconds. If I ask the same question to somebody who has no idea, the response, and if I make the facts a bit more elaborate, comes out wrong. And as I was saying before, a lot of the obligations of the WTO, because they view the conduct, they are expressed in very aggregate terms. And there are many mistakes. I can show you, if we have later time, or if there are questions, a number of cases where the appellate body said black, white, and gray. Everybody says the crown jewel, but how many people sit down like I had to do it, and I still do it every year, and read each and every decision of the appellate body, paragraph by paragraph? Black, white, and gray, a number of times, without any explanation. Now, why did they say non-liquid, and why I'm still in favor of non-liquid? I'll tell you why. Not only because we are both, you and me, Stefan Riesenfeld, students, no. I say it also because of the costs associated with judicial activism. As you know, I'm not a Trump guy, and I don't like at all the way the US behaved towards the appellate body. I disapprove from A to Z. But the US has made some very good points a number of times. I cannot close my eyes to this. They say, wait a second. How on earth can you interpret this in this particular way when it is clear from the negotiating record that this is what we agreed? This is what we came out from them. That's what I sold back to DC. And now you tell me that I negotiated something else and there's a different agreement. I mean, these are legitimate concerns. Now, in the name of an extreme textualism, which keeps changing levels from decision to decision to decision, they've done all sorts of atrocities. Now, and they have expanded the coverage of law. There are dozens of examples. I cite in the book from subsidies agreements, reasonable benchmarks to amicus curiae. Why can't they say, guys, I'm sorry, this, maybe you contracted something, but it is at least unclear. I don't understand what is the discipline. Take it back. You negotiate it. Give me something I can work with. Because if I make a decision here, I might be preempting your discretion. And I might be delegitimizing the whole process of lawmaking at the World Trade level. Do I really want to do that? The agency costs are substantial in these cases. Why can't they do that? Why can the International Court of Justice, which can judge on principles of law, and has done it in the past, as you know much better than me, has the right to say non liquet? And WTO courts not even once. There's not one single case. And they judge only on trade law. It's crazy. There's no other explanation.
Okay, so I before I get a revolution on my hands from all these people who have done some wonderful questions, let's just turn to them. So here's one. It appears to me that the analysis on market reform has not fully incorporated the non-market aspects of China's IP regime, including the incorporation of intellectual property into China's economic planning mechanisms, restrictions on tech transfer, payments, misuse of antitrust laws to advance industrial policy and not facilitate competition. Can't the TRIPS agreement, including its preamble requirement that IP is a private right, adequately address forced tech transfer and other state interventions? And basically, the writer says the reality is that China's IP regime has rarely been the target of WTO cases. The US has only brought two, and the most recent one was under the Trump administration on TT issues, which helped precipitate significant legislative changes in China. And they're basically wondering whether your analysis applies equally to China's IP regime. And basically the bottom line is most TRIPS provisions are untested. So that's the question.
It's a very good question. First of all, I don't know what you qualify as TRIPS disputes. So I should tell the author of the question, I'm finished, almost done with my work, because while I was doing this book, I've been working for the last 3 years on my book on dispute settlement. And I have come to the conclusion that I should qualify as TRIPS disputes the disputes mentioned as TRIPS disputes in the WTO. And if you take it this way, it's 4 US, not 2 US disputes, as the WTO acknowledges them. But there are very few, I'm not saying the opposite. Now, there are 2 things I would say about this. First, preamble is an extremely weak legal basis. I have seen not one single case where somebody won based on the preamble. And I cannot see how a very textualist body like a panel or the appellate body would ever find in favor of the EU, US, whoever, based on the preamble. And second, remember what we deal with here is just WTO disputes, not antitrust disputes. I'm not saying that, of course, you can do all sorts of things through antitrust or maybe through domestic IP laws in China, but this is not part of the concern for this book. What we care about, I accept it's a problem. I'm not saying we're dealing with all of China, but we're dealing with China as a WTO member and how much of this can be addressed through our proposals.
So here's a question from somebody we both know and respect, Bill Alford at Harvard. And he's pushing back on your political economy points, both in the 1990s and now. He says, yes, the road to accession was greased with the narrative that it would promote economic and political change, but that's not what China's leaders were saying or doing. And even in the West, there was some skepticism about that narrative, which was pushed for expediency's sake by the Clinton administration. So he doesn't think really people believed it. And certainly they weren't hearing it from China. And then the second point, can you elaborate on the actual issues in your proposal? With the Chinese leadership seeing its model vindicated and ours failing, what meaningful issues would China accept major change on?
Okay. On the first point, I mean, I cannot say much. Maybe he's right, but this is the overwhelming majority of, maybe there were, and I cite a number of skeptical people. There are people, he's absolutely right, Dr. Alford. There are a number of people who said, well, this is all, to use Biden's terminology, malarkey. Don't pay too much attention here. This is cheap talk, hogwash, as you would say in Cuba, you and me. But the leaders took the opposite view. The European Union leaders clearly said, this is the road to market economy. Clinton and Bush, when they were, both of them coincided with the accession of China, they said the same thing. The DG of the WTO said, China is on its way to market reform. And so, I mean, it's difficult to say, yes, there was skepticism, but overwhelmingly, there was this thing that, and if I'm wrong that this was not the overwhelming view, quite frankly, then it is a total political economy concern. I mean, they did it knowing, they did satisfy particular lobbies who would win anyway, knowing that China would never change. On the second point, I wish I could see the future, of course, because if I could see the future, I'll be in a different line of business. I would not be doing what I'm doing here. But as I said, China has a number of choices now before it. One is it knows now that the US has no problem going unilateral. It knows there is a trilateral commission meeting once a month and discussing China issues. It also knows that its position in the WTO, they're not stupid. They know they are on the twilight zone between legality and illegality through SOEs and so on. So what is their response so far? The response so far has been, I'll deal bilaterally with different players. I'm doing an investment agreement with the EU. I am doing a trade agreement phase 1, phase 2 with Trump administration. I am doing RCEP, a little bit regional with some players I can control in my neighborhood. Well, eventually though, they will have to come to the WTO with all those things. Somebody might take the phase 1 to the WTO. This is not MFN. Give me what you give to the US. Somebody might take the European agreement, investment agreement, to the extent there is mode 3 in services and say, give me what you give Europe. These things can happen. Now, to me, the big problem is now, as it was then, that the EU and the US, and I'm sure I did not mention it before, but Bill Alford gave me the opportunity to make it now, this comment, did not get together when they're negotiating with China. There is no evidence, we didn't find any evidence of EU and US being in close cahoots in the 90s when China was anti-porters. There were no common requests. They were all bilateral deals with China. And that's how the Chinese protocol of accession looks like. Well, maybe if they get on one side this time, things will be a little bit different. And then China will be forced to sit down and negotiate.
So we have a question about your suggestion of drawing from the TPP's no enforcement of force technology. That's from no performance requirements section of the investment chapter, which is, of course, subject to a self-judging essential security clause. And doesn't that pretty much gut it? Because the United States, for example, under Trump, said TikTok is an essential security. And because of that, we're going to force the secret sauce of TikTok to be given to this Trump ally, I believe it was Oracle, which sounds like a tech transfer under the guise of essential security. So isn't that a problem?
So I want to understand the question properly. The question is to what extent it is a problem for the US to appropriate foreign technology in the name of national security?
And the same for China. Remember, the essential security clause is now increasingly subject to almost self-judging. And even in the WTO appellate body, it's all, well, just good faith. That's all you have to be satisfied.
Now, first of all, on national security in the WTO, the appellate body has not spoken authoritatively on Article 21. The last report came from our common knowledge acquiescence Professor Dr. Abisab, the Russia vehicles case. And there in this report, what Abisab did was he said, I am going to be deferential. If you tell me national security, I'm not going to meddle like Scooby-Doo and the meddling kids. I'm not going to meddle too much here, but you have to respect the context. And the context is you can invoke national security, as Article 21 says, under specific circumstances. I am at war. I am threatened by war. This, he said, I will exercise not judicial activism, but I will interpret. I will try to see, I want to see evidence that there is either war or threat of war. So the national security part, it's a very carefully drafted report. Now, forget if we like it or dislike it. If this is the last word, you cannot invoke it left, right, and center. This is why the US was so upset. You see, when the US imposed safeguards on steel and they said national security, in the beginning, everybody was laughing, but this is where we were. Then comes this report. That's why the US was so much anti. Says, oops, now they will ask to what extent I am in a war state or threat of war state. And I'm in none of the two. So I cannot invoke national security. No. So the differential standard of review is the subsequent analysis to an objective examination of the facts. Am I facing this situation?
So you think even with an essential security clause, it could still work if you adapted that provision from the TPP?
I mean, exactly. I mean, if you keep it, again, Jose, I say, if this is the word that an eventual appellate body or in the future panels, if we move to one instance adjudication, accept. But to me, it sounds as a very reasonable interpretation, as a reasonable framework to understand Article 21. Because I'll give you an example in a moment. I don't want to see judges meddling with national security very much. Yes, they can discuss if we're in a war type situation, but if I am there, quite frankly, I don't look at the European Court of Justice. The European Court of Justice is always, even within Europe, a much more intense integration model, very differential when somebody said national security. The Greece case is very informative.
Okay. Well, let me go to some of the questions we've had in the Q&A for now a while. Some of them elaborate on some of the discussions we've had. So here's one. The difficulty with Chinese enterprises is that they are, is whether or not they're state-owned is not the problem. Huawei has never been state-owned. Rather, it's a model of formal and also informal relationship with the party, the Guanxi. How can we Western lawyers capture such problems in legal language? And this is the deep skepticism of ever having legal rules that can capture those complex relationships. I mentioned New York Times as of yesterday had a long story about a private publishing company. And the mistake made by its owner was that she expressed sympathy with a human rights professor who was imprisoned. And all of a sudden, she got her license pulled on what sounds like political reasons. That's a private company in China. Again, back to the Castro point, which is Xi's point. Everything with the party, but nothing else. How could you possibly capture that in legal language controlling just SOEs, for instance?
I mean, this is an excellent point. There are two things here. I don't know how much of this is a problem for the WTO, because if we talk about Huawei, the Chinese giant, the problem there is when it invests outside the WTO, then it's a question for CFIUS in the US or the European framework. It's not a question for the WTO per se, unless if it is Mode 3 services. But again, you're not obliged to give China national treatment on, you can stop and say, no, I'm sorry, I'm not dealing. Or you can invoke whatever in Article 14 exceptions. When it comes to trade, the question is, how do I penetrate the market of China? It's a very different problem if Huawei has links with the Chinese government. I'm not saying it's not, but it's a very different, it's a lower, let's say, intensity problem than when Huawei goes to export markets. Here, Jose, that's why I mentioned it very fast, but in the book we spend at least 7-8 pages discussing DS437, which to me is a mystery, this case. When you deal with this type of entities, and you're right, it's very difficult to write a complete contract here, so that's where you need your a team of judges, the best possible you can have, they will have to think in terms of conduct of the company and instead of structural links to the government. And you can use the conduct as proxy for structural links. And if there are no structural links obvious, then it becomes a much more important proxy with much more relevant than otherwise. Now, here you need to look into market behavior. You need to see to what extent the agent operates in real life as any other private agent, or to what extent exercises government policy. Unless you do this type of analysis, which the appellate body has thrown out of the window saying, I don't care about trade effects. My God. So what do you care about? You don't care about intent. You don't care about effects. You care about what? Unless if you go down this road, it is impossible to respond to these questions. And this is why I say, I mean, yeah, you can maybe add a couple of examples in an illustrative list, so you avoid type 2 errors, but you need very skillful judges to address this type of cases. These are very difficult cases. And you need a total reorientation of the standard of review. You have to say black on white, from now on, I will be looking into actual behavior in the markets, exactly what the appellate body has never done.
So we have a question. When you drew on the CPTPP, one of the participants pointed out that the CPTPP has some strong labor provisions. And do you see a possibility of at least that being a way to insert either labor rights or human rights? Because after all, President Xi Jinping expressed vague enthusiasm for China joining the CPTPP. So if they can accept labor provisions, couldn't they accept something comparable in the WTO?
Honestly, they haven't said anything so far. My very dear friend, our very dear friend, Mark Wu, who is now at the USTR officially on leave from Harvard, has a very nice paper. I liked very much his paper, and we cite it a lot in this book, where he says no matter what type of commitments China will you impose on China, they always find a way to avoid them for a number of reasons. You know, I think it depends. I'm a little bit, I differ from my very dear friend Mark on this. I think it depends on how you formulate those commitments. I mean, if you make commitments which are, the language is precise, and judges will find it difficult to err for whatever reasons, it will be difficult for China to totally disregard. Mind you, China, and I say it in full awareness of what I'm saying, with the possible exception of one case, has always implemented adverse rulings before the WTO. China is not a bad player in the WTO. They have not brought China to the bench. There are not many cases in the docket against China. That's true. But whenever China lost, with the possible exception of one case, China has implemented. So when they take a commitment, they usually honor it if the past is a judge. Now, would they be willing to take a commitment along those lines? You know, I'm skeptical about labor rights because this is not the model of China. This is not human rights-based society or human rights-driven society. I would find it difficult to see how they would accept. I can see China accepting to reduce a little bit of the leash on SOEs, but changing to becoming something like the US or Western democracies, I think to me it's a long shot, at least in the short run.
So a couple of the questions allude to something that you do address in, I think at page 182 of your book, in chapter 6, you talk about the inadequacy of Chinese courts enforcing IP, right? And so the backdrop here is that these trade rules are built on another assumption, an embedded liberalism, which is that you have independent courts that form the backdrop for enforcing the rules. And for a while, it looked like that's what China was doing, was training people, including judges, lots and lots of lawyers, to enforce the rules inside China. I don't get that impression anymore. That is, when you say that they've backtracked, I think the courts have backtracked, but maybe I'm wrong when it comes to trade. So isn't that a fundamental problem if you don't have the backstop of national courts and national rule of law.
Absolutely. And this is why later on we have this part where the part where you refer to is where we explain the size of the problem, building on the work of people like Peppercorn, Dutch sociologist, lawyer, Dutch Chuck Sable, plus Ben Liebman and so on. We, my very dear André Sapir and myself, we propose that we should move into a model, at least for China, of what you have in the government procurement agreement, the so-called challenge procedures. Now, what is a challenge procedure? I need to have a short digression, if you don't mind, of less than 1 minute. In end of the 80s, the US, there are a couple of US companies who want to enter the government procurement market for building toll ring systems, toll ring in the highway in Europe. So they want to be there. They have excellent technology, very performant companies. They look everywhere to see what is the next highway built in Europe. They find one in Norway, in Trondheim. But between doing the request and everything to participate in the tender and so on, the Norwegians, believe it or not, even Norwegians can be, let's say, less than Catholic or less than kosher. They had given away the work to somebody they knew. The mayor gave it to a friend of his. So now the US companies are left out. They persuade the US government, say, look, this is ridiculous. They didn't respect transparency, nothing. There was no notice of tender. They take them to the GATT and they win the case hands down. Now, they win the case hands down, but you have a tolling system in Norway. So what do? You tell Norwegians, undo the tolling system and do the competition again. Who is the losing part? Who is the injured party here? Anyone could have won. Why the US companies? A German company might have won. A Cuban company might have won. How do we know those things? So to avoid these problems, in the new government procurement agreement, they introduced challenge procedures. What is a challenge procedure? Every WTO member who is a signatory of the agreement must introduce a forum. Could be a tribunal, could be an admin forum. And Jose Alvarez, me, Dr. Wilhelm, anyone, Alexis Sanborn, we can go and say, you violate, you state, not you individual, you Cuba, you US, you Europe, you violate the agreement. You have to do so fast relief, so don't have to wait. So we suggest this should be the case for China. We should have challenge procedures for IP, for all these areas that we care about so much. Because otherwise, if you leave it to Chinese courts or if you leave it to WTO, my God, it would go on forever, and forever is a long time.
So we have a question about the Accession Protocol, and one person is raising questions about whether that was the full extent of the agreement. Weren't there other efforts, side letters, negotiations, quiet diplomacy, to address some of the structural inconsistencies? How much do we know of what was done? It seems surprising, I guess, just how limited that accession agreement was.
So we spoke to a number of negotiators in the two sides of the Atlantic, André and myself. On this issue, I must say that the responses are not exactly unanimous. I mean, some people say this is all you have. Some people say there were other type of promises that we've never seen. You need different powers, investigating powers, to see if there are side letters, for example. Some people think that the language says is enough, and they're surprised it's been under-enforced. Some people say this is the most we had, and most people say, don't forget, we thought they were changing. That's why we wrote the book the way we wrote it. If there were other things which are unofficial, quite frankly, they never came to my attention. But I've heard people say, yeah, there were all sorts of oral promises, don't worry, things will happen, but they never happened, at least not in a transparent manner.
Mm-hmm. So this is a question that gets you a little bit outside of the two issues you focus in the book. But, you know, the Trade Policy Working Group has put things into buckets. They say there are beggar thy neighbor type policies that should be off the table and everybody should agree not to do those. There are some things that should be subject to bilateral negotiation. And then there are things that are subject to multilateral rules. And I guess you're focusing on the two things that you would put in the multilateral bucket. But can you say more about this? What would fit where? If we're really trying to get to a reformed WTO that works just beyond SOEs and beyond tech transfer?
To me, the first for the WTO, I mean, what I like very much in this question is that the big problem of the WTO, in my view at least, and the view of my co-authors, is not the apple at body crisis. I mean, this can be addressed quite fast, but it's like changing the order of the furniture at the deck of the Titanic. I mean, honestly, unless if we can revive the legislative function, the WTO will be best before. We'll have a date for consumption. To me, to revive the legislative function, and this again, it's not off the cuff. This is part of all the work I've done with Bernard Hoekman over the last 10 years. You have to rethink the model of integration in the WTO. It is impossible to, when we talk about a world where we have behind the barrier instruments, segment trade. It's not tariffs anymore. Tariffs are irrelevant. Your average tariff is less than 3% around the world. I'm not saying there are some markets where they matter, but overall, the big picture, irrelevant. What segments markets is public health policies, environmental policies. And these are areas where there is not one single serious person, I think, who will say, treat them the way you treat tariffs. You can take a tariff from 10 to 0% without any problem, but you cannot say I will not address environmental concerns. So what, I will live with distortions or public health concerns? There the question is, how do I rationalize? Now, to rationalize, we need to have you and me the same concern. The moment you say the same concern, you reduce the size of the tables around, of the negotiators around the table, because we don't have all the same concern. Switzerland in 2021 and Switzerland 1921 is two different Switzerlands. And many African sub-Saharan states are where Switzerland was 100 years ago. It would be inhuman to ask from those people to forget feeding their people and start investing in environmental protection. You cannot do those things. You have to factor in the level of development and the capacity of each state in order to discuss. Now, if you take all of this into account, we have to move to a model of variable geometry, where we allow those who want to go further faster to do so, while the door remains open for everyone to join in when everyone can join in. Unless if we do this, the WTO, as I said, and actually, sorry, last sentence here, more or less, when we wrote this paper in 2015, I will never forget, we went to Stanford, Cal Bagwell invited us, and a number of people said all sorts, oh, this is regionalism, and you are, This is what happens in the WTO nowadays, 2021. The so-called Joint Statement Initiatives, the JSIs, which are the only thing functioning now in the WTO, is a subset of the membership negotiating on specific issues. There is no other way. Either we accept it and we go forward, or we don't, and then we'll see free trade areas everywhere. Last sentence, if you go to the World Bank webpage and you Google deep trade agreements, a friend of mine is doing it, Michele Ruta, you'll find dozens of agreements where they have hijacked the WTO agenda. There is appetite for trade agreements, but between like-minded players. You cannot pretend that we can all work at the same pace. It doesn't make sense.
Well, and so I guess that raises, there's at least one question on economic nationalism being on the rise, but you can also say regionalism is on the rise. Is there anything wrong with a bunch of agreements like the TPP solving this among like-minded states? Not everybody's convinced that, David Ricardo was right anyway. So they'd like to, do business with like-minded states. Is it a problem other than that wonderful building in Geneva won't be as occupied as it is? But remember, it was originally the ILO, so we could go back to being the ILO. Why not? I mean, what's wrong with regional agreements that are in depth, like the TPP?
if you ask me, and having taught with Jagdish for 15 years, he hates me for those things. There is, to me, this is the way forward. The question is, do you want to have those agreements between few players outside or inside the WTO? And I say you should have them inside. Open the door to variable geometry, because these agreements will happen. They do happen on an everyday basis. The US cannot sit down and negotiate recognition agreements concerning the measurement of risk assessment on hormones in bovine meat with St. Kitts and Nevis, because they don't have, first of all, the instruments. They can do it with Canada. They can do it with Europe. They can do it with Norway, with Switzerland, but that's about it. So do you want now to reduce transaction costs by harmonizing some rules? Do it. Let them do it. If you don't do it, what is the counterfactual? Unilateral policies, even higher transaction costs. So to me, the moment we finished the GATT agenda, tariffs, and we moved into negotiation of behind the border instruments, this was the moment where, unfortunately, we had no one to steer the negotiators, no helmsman or helmswoman in the WTO at the time to steer the WTO model into variable geometry, into what you call regional agreements. It cannot work otherwise.
Well, we've gone through a lot of the questions, and I apologize for those that we've not gotten to. And I think we're actually at the very end of the hour, unless you want to say any closing 3 seconds, Petros.
Thank you very much for inviting me. It's always a pleasure to see you. And thank very much, Dr. Catherine Wilhelm, who is a Columbia alumna. That's why she's so good, and gave me amazing comments in my draft. And of course, Dr. Sanborn for organizing the whole thing.
Thank you, Petros. We'll have you back, and some of the folks that you cite, perhaps, like Curtis Milhop. So tell him that we might be after him to discuss Chinese corporate law. Take care, and thank you all for joining us.
Thank you.